Assalamualaikum and hi, my name is Nurul Hasana. So for introduction, I'm going to talk about why does registering trademark is important. It is important because it protects a brand and helps avoid confusion among customers. However, not every trademark application get approved. Different countries have their own rules about when a trademark can be refused. In Malaysia, trademark can be rejected if it's not distinctive enough, offensive, or conflict with an existing well-known brand, even if that brand isn't registered locally. In the United Kingdom, trademark can be refused if they contain offensive or illegal content, or if the application doesn't meet the formal requirement like the proper documentation. So, what about US, United States of America? So, in US, the main concern is whether the trademark might confuse consumer with an existing one, and they also don't allow trademark that are just descriptive and use government symbol.
Assalamualaikum and hi everyone, my name is Antisar. So today I will explain the grounds for refusal of trademark registration in Malaysia under the Trademarks Act 2019. These grounds are divided into two parts, which is absolute grounds and relative grounds. First, we will discuss about the absolute grounds under section 23. Under section 23, subsection 1, para A, a trademark may be refused if it cannot be presented graphically and distinguished from other products. For example, trademarks that involve smells or sounds without any clear visual form may be rejected for being unclear and vague. Next, under section 23, subsection 1, para B, marks that are too generic or commonly used in business can also be refused. For instance, if someone tries to register the word junk food as a trademark, it will be rejected because it doesn't help customers identify a unique product. This can be seen in the case of Korea Wallpaper against Pendaftar Cap Dagangan 2019, where the High Court rejected the mark Korea Wallpaper because it lacked distinctiveness and was too descriptive. Apart from that, Section 23, subsection 1, para C, also rejects trademarks made entirely of descriptive words like fresh banana because it only describes the product and not the brand. In the case of Makila Limited against the Registrar of Trademarks 2023, the mark Kauri was initially rejected because it was considered descriptive. However, the High Court allowed it because the word was not commonly used in Malaysia, especially in Japan. Other absolute grounds for refusal include if the trademark is just the shape of the product, if it's against morality or public order, if it includes national symbols, and if it threatens national security. Moving on to relative grounds under section 24. Under section 24, subsection 1, a trademark will be rejected if it is identical to an existing mark and used for similar products. For example, no one can register the word Nike or Nike for sportwear because it is already a registered mark. Section 24, subsection 2 also prevents the registration of marks that are similar enough to cause confusion, even if the spelling or design is slightly different. This can be seen in the case of DJ Auto Components against FBK System 2019. The defendant used FBK brake shoe and device, which was similar to the plaintiff's FBK mark for auto parts. The court then ruled in favor of the plaintiff, saying it could cause confusion for the customer and it was done in a bad faith. And lastly, under section 24, subsection 3, a trademark will be refused if it is similar to a well-known trademark, even if that trademark is not registered in Malaysia. This is to prevent misleading the public and to protect famous brands from being copied for profit. In conclusion, Malaysia's trademark law provides a strong system to ensure that only valid and unique trademarks are accepted. The absolute and relative grounds under section 23 and 24 are important to maintain fair competition and protect consumers from confusion.
Okay, so United Kingdom trademark registration can be refused on two grounds, which is absolute and relative ground. So for absolute ground, it focuses on the trademark itself, regardless of any earlier right. For a trademark to be registered, it must be distinctive enough to identify a good or service of one business or another. Marks that are too generic, descriptive, or common won't be accepted unless they can distinctiveness through use of over time. For example, Nestle tried to register the shape of Kit Kat bar, but the court ruled that the shape was just a product feature, not a trademark. Similarly to trademark that consists only of shape necessary for technical function or those are offensive against public policy will be refused. Another important reason for for refusal is if the application was made in the bad faith, such as when someone tries to block competitors or exploit another brand reputation, like the case that involving transport of London, that come up with the phrase of mind the gap. Okay, so what about relative ground of refusal? So, for the relative ground of refusal, it will come into play when a new trademark conflict with existing right. If the new trademark is similar or identical to an earlier one and covers the same or related goods or service, registration can be denied to prevent consumer confusion. This also applies to marks with strong reputation and where the new mark might unfairly take advantage or harm the earlier marks distinctiveness or reputation. A good example that we can take here is the case of Lidl and Tesco case, where Tesco use of a similar sign was found to take unfair advantage of Lidl well-known mark.
Hi everyone, so today I'm going to talk about why some trademark applications get rejected in the United States. In short, trademark helps businesses to set up, but not all the names or logo can be registered. The United States Patent Trademark Office will reject any mark that doesn't follow the rules. There are two main reasons for the rejection, which are absolute grounds and also for the relative grounds. First, absolute grounds. This means there is something wrong with the trademark itself. The trademark must be distinctive, where it should help customers know your brands. If it is too general or descriptive, it will be rejected. A famous example is Booking.com. At first, it was rejected because the booking itself is a common word, but the court later allowed it because people link Booking.com with the one specific company. Another reason for rejection is confusing similarity. If your mark sounds or looks too much like another brand, people might get confused. For example, in the case of Master Energy and Thunder Beast case, where Master said Thunder Beast was too close to their slogan, which is Unleash the Beast, and the United States Patent and Trademark Office agreed with it. Marks can also be refused if they are misleading. For example, the brand Healthy Ham got rejected because it made the product sound healthier than it actually was. Lastly, names that are just surnames or used only for decoration can be also refused unless they have become known as a brand over time. Now for the relative grounds, this is when the new trademark is too close to an existing one. If the names or logos are too similar and people might think they come from the same company, then USPTO can reject it. Also, for the family brands get extra protection. For example, in Apple against Pear Technologies, where Apple argued that pear was too similar even though it is a different fruit. Hence, the court agreed, saying it could affect the Apple Storm brand. Lastly, if someone files a trademark in bad faith, like just to block others or take advantage of a famous brand reputations, it might be refused as well. So, in short, for a trademark to be accepted, it must be original, honest, and not confuse people. If it doesn't meet these standards, it will be likely to get rejected.
Let's make a comparison between the grounds for refusal of trademark registration in Malaysia, the United Kingdom and the United States. Although each country has its own regulations, they all share the same core principles. First, all three jurisdictions require a trademark to be distinctive. If a trademark is too generic, descriptive or ambiguous, it will be refused, unless the applicant can prove distinctness through use. In the United States, under the Lanham Act, trademarks may still be registered if they have occurred a secondary meaning, which means the public has come to associate that mark with a particular source. And These countries also prohibit trademarks that describe the kind, quality, quantity, or geographical origin of the goods. This is to prevent companies from monopolizing common language that everyone should be free to use. Also, shapes or functional features cannot be registered as trademark because such features are better protected under patent law, not trademark. This stops businesses from gaining unfair control over useful product designs. Apart from that, trademark that goes against public morality, use offensive language, or contain national symbols without permission will also be refused in all the three countries. As for bad faith, it's not clearly stated in Malaysia's law, but it is recognized in the UK and US. Both countries will refuse registration if the application is made with dishonest intent or to take unfair advantage of others. Now, on relative grounds, all three countries will reject trademark that conflict with existing ones or that may confuse consumer. Infringement happens if someone uses a mark that has already been registered by another party. However, the difference is Malaysia still requires a trademark to be presented graphically, which can be a challenge. In contrast, the UK and US are more flexible, accepting non-traditional marks like sounds and motion. In conclusion, while there are some differences, Malaysia, the UK, and the US follow similar principles when it comes to trademark registration. They aim to protect businesses and consumers by ensuring that only valid, fair, and distinctive trademarks are approved.
So, to sum up, registering a trademark is not always easy because each country has its own rules and standards. But what I noticed is that Malaysia, the United Kingdom, and the United States all want trademarks to be unique, clear, and not confusing or misleading to customers. All three countries check two main things before approving a trademark: whether the mark itself is distinctive enough and whether it is too similar to an existing trademark that could confuse people. Some details different, like Malaysia still needing a graphical representation of the trademark, while the United Kingdom and the United States are a bit more flexible about that. This shows how important it is for anyone applying for a trademark to understand the rules in each country, so your application don't get rejected. At the end of the day, these laws protect both trademarks owners and the consumers by making sure brands are clear and trustworthy.